Committee on Oversight and Government Reform will come to order. The committee meets today to consider reporting a resolution to the House of Representatives finding the Attorney General Eric Holder, Jr. in contempt of Congress. On the night of December 14, 2010, in a canyon west of Rio Rico, Arizona, U.S. Border Patrol agents were engaged in a shootout with armed Mexican bandits preying on illegal immigrants. One of the agents was 40-year-old Brian Terry, a 3-year veteran who had served as a U.S. Marine and gone through boot camp at Camp Pendleton in my district. During that firefight, a bullet pierced Agent Terry's aorta, and he died in that canyon. 2 weapons were found at the scene. They were later traced to an operation conducted by the Department of Justice called Fast and Furious. 16 months ago, this committee, along with Senator Chuck Grassley, launched an investigation into whistleblowers' allegations regarding Fast and Furious. We became involved only after Senator Grassley was told he would not receive answers from the Justice Department because, in fact, he did not have subpoena power and was not the chairman. In the course of our investigation, the committee has uncovered serious wrongdoing by the Justice Department. That wrongdoing led to 2,000 weapons crossing the Mexican border that cost lives on both sides of the border, including Brian Terry's. A year and a half later, the Terry family is still searching for answers. The operation contributed to the deaths of countless Mexican citizens. It has soured our relationship with our neighbor to the south. It's created an ongoing safety problem here in the United States, in which even the Attorney General has admitted more lives could be lost. The Department of Justice has fought this committee's investigation every step of the way, starting with an unequivocal denial that it used the reckless tactics we now know were used in Fast and Furious. The denial proved to be false, and ultimately the Justice Department withdrew it. They withdrew it in December, having given it to us in February. Today's contempt is in no small part because the materials between the time a false statement was given to us in writing and later affirmed in sworn testimony by the Justice Department's representative, an officer of the court, a lawyer, and now the dean of a law school, was ultimately false. That intervening period remains one of the areas of investigation. It's clear that Congress relies on its ability to get truthful testimony when investigating wrongdoing in and around the executive branch. In spite of this lack of transparency, the committee has managed to piece together much of what happened, and we believe we can help participate in making sure it never happens again. But our work is not complete, and we need the Department of Justice to cooperate. Thus far, the cooperation has not been forthcoming. Over and over again, the Department has sought to protect its political appointees. It has used this investigation by the Department's Inspector General, which has been pending a very long time, as a reason not to cooperate. We are now on the second Inspector General. There's been no interim report, and although they say it will be forthcoming within a month, we and the American people need answers sooner, not later. The Attorney General has, in fact, said he has gone to extraordinary measures to participate and to help. We've received to date approximately 7,600 documents. A great many of those documents are, in fact, responsive to other operations conducted before he was Attorney General. And those documents pale in comparison to the 80,000 documents or more that the Inspector General has received. Our purpose has never been to hold the Attorney General in contempt. Our purpose has always been to get the information the committee needs to complete its work that it is not only entitled to, but obligated to do. We had offered the Department an accommodation to address its concerns about information related to ongoing prosecutions. If the Justice Department had delivered the documents they freely admitted they could deliver, we wouldn't be here today. As late as last night, in discussions with the Attorney General, his offer was only to give us a briefing and such documents as supported the briefing, and then only if we ended the investigation. Contempt today is not about whether we end the investigation or not. It is about a narrow subset of the documents that the committee must ultimately receive. The subpoenas are 8 months old. We have not received a credible reason for them not being supplied, and in fact, no constitutional assertion has occurred. Rather, it is the duty of the executive branch and its agencies to represent itself honestly before Congress and to make available such transparency as necessary for us to fund and authorize it now and in the future the request of this and future Presidents. Only today, only a few minutes before the gaveling of this markup, did we receive from the Deputy Attorney General a letter dated today, not spoken of last night, which says, and I'd ask unanimous consent the entire letter be placed in the record. Without objection, so ordered. In the first paragraph, it says, I write now to inform you that the President has asserted executive privilege over relevant post-February 4th, 2011 documents. It goes on for several pages. As I speak, the committee is evaluating this. We have verified that no communication from the President has arrived before the House. Additionally, at least in a preliminary evaluation, we discover that the President, well after February 4th, has said that, in fact, he has not discussed this and was not made aware of it. Additionally, the Attorney General has repeatedly given us testimony showing that he did not speak to the President about this. I now read for the record from page 25 of When Congress Comes Calling, which is from the Constitution Project. And I apologize if this seems preliminary, but this communication arrived only within minutes of the start of this markup. Executive privilege. The President's communications privilege, and I quote, the communications in question must relate to the quintessential and non-delegatable presidential power that requires direct presidential decision-making. The privilege is limited to the core constitutional powers of the President, such as the power to appoint and remove, the Commander-in-Chief power, the sole authority to receive ambassadors and public ministers, and the pardoning power. I claim not to be a constitutional scholar, but the House is currently working to find out what assertions may in fact arrive, and we will take notice of them. Having said that, more than 8 months after a subpoena, and clearly after the question of executive privilege could have and should have been asserted, this untimely assertion by the Justice Department falls short of any reason to delay today's proceedings. We have made many attempts to accommodate the Justice Department. Originally, some 22 areas were on our subpoena, many of which were never complied with. We narrowed 3 master areas to 2 in a letter on May 18th unprecedented letter from the Speaker of the House asking for cooperation and narrowing the scope of the subpoena. Since that time, we have further narrowed to one area for purposes of contempt, and we have been denied. The Attorney General has refused to cooperate, offering to provide subpoena documents only if the committee agrees in advance to close the investigation. No investigator would ever agree to that, and as you could understand, the other information related to those in the chain of command responsible for Brian Terry's murder and the death of individuals both north and south of the border cannot be concluded simply based on a briefing about post-February 4th. The Attorney General says that his offer is extraordinary. The only thing extraordinary about his offer is that he is asking the committee to close an investigation before the committee even gets to see the documents. He is pretending to offer. I can't accept that deal. No other committee chairman would. This committee will be considering today a very narrow contempt, but members on both sides of the dais have repeatedly said that we owe it to the Terry family to get to the truth. It is my intention to continue post-contempt to do our job while meeting our other obligations to pursue waste, fraud, and abuse in our government. And with that, I recognize the ranking member for his opening statement.